Thank you, Tommaso, for the introduction. Thank you for the invitation. I'm very happy to be here and very honored to be a part of this panel. You probably wish I could do the presentation in Italian. I wish I could, but maybe it would be even shorter if it was in Italian. So I would like also to thank the ladies during the translation services. I mean, the level of the translation is just amazing. I'm very impressed. So for those who would like to follow in Italian, I can only encourage you. If the level is as good as in English, it should be very good. So after gun jumping, I just wanted to say a few words about other procedural breaches in recent merger cases. And gun jumping has been a very hot topic recently, but we've seen also a lot of movements from the European Commission on other procedural breaches in merger context. And I think it's been a clear message to the market that the Commission is taking those breaches very seriously. So I'll come back to a few of those cases, especially the very recent one, the GLM Wind one, which led to a 52 million fine, which is obviously quite significant. And then I'll say a few words, if time allows me, on document request, as Tommaso said. I think this is also something where we see quite some developments recently in the Commission's practice, and I think for the practitioner in the room, it's a point to take into account when you start working on complex mergers. So very quickly on those procedural breaches, I think the first case I wanted to come to is the GELM Wind case. So that's a case that started, it was actually notified to the European Commission in January 2017, but then apparently a third party informed the Commission that GE was developing some products in the same space as the merger field that GE did not disclose during the merger discussions, nor the Form CO. So what GE did is withdrew the notification and refiled with the further information. So the deal was cleared, but the Commission opened an investigation on misleading or incorrect information that took, nearly 2 years and led, as we know, early April to a 52 million fine for the provision of misleading information. And the reason there is because the Commission considered that that not providing this information was actually a serious infringement, and that led actually the Commission, it prevented the Commission from having all relevant information for the assessment of the transaction. So in that case in particular, it's interesting to know that the Commission was examining a parallel transaction between Siemens and Gamesa, and the position of GE, after the transaction obviously would have had an impact on the overall market structure, and knowing what was in development on GE's side was very important for both transactions. So that's why the Commission considered it was actually a serious infringement. But interestingly, the Commission sanctions that kind of behavior when it's done intentionally or negligently. And you may remember the Facebook case, which led to a 110 million euros fine, which was back in 2017, where the Commission also found that it was actually a negligent error from the parties. Here, similarly, the Commission considered that it was only negligent, but still said that it was based on the fact that the parties, especially GE, who's doing a lot of acquisition and is pretty aware of the way it works before the European Commission, should have been aware of the relevance of this information for the Commission's case. So that's quite interesting. I'm actually quite curious to see, what standard you would need to reach to be able to be found intentionally misleading. I'm not sure the Commission is yet to go this path, but I'll leave Michele to react on this if he wants. So that's the first case, which led actually to sanction. And then, as a number of speakers mentioned, there are a couple of cases in the pipeline as well from the same period. Actually, they were initiated also in July 2017. The first one is the Merck Aldrich case, where, again, the Commission is suspecting that the parties have failed to provide information on important innovation projects. And in that case, the Commission thought, or is allegedly thinking, that it was particularly relevant because this innovation project, actually, which were not disclosed during the proceedings, would have had an impact on the remedy package, because that decision led to a remedy. So the solution was actually that Merckx licensed the technology to the buyer of the remedy package. So that was solved, but it considered that it should have been disclosed during the investigation. So a few thoughts on this ongoing investigation. It's been running for almost 2 years. And it's quite interesting to see the time it's taking, actually, because in that case, it's quite clear, according to the Commission's press release, that the information was important for the assessment, that it was actually not provided. So I'm not really sure what else the Commission can decide, but for the fact that there was a misleading or an error in the provision of the information. So I'm wondering whether this is a case where they're looking into, whether it was negligent or not, or just whether the lawyers are very good at defending the case, so this is taking so long. Then moving on to the next case, which is the Canon Toshiba. I will try to be quite fast. It's been also mentioned by Giuseppe. There, we're back in the field of gun jumping, but in an interesting context, which is the warehousing structure. So in that case, we had a scenario where the parties wanted to transfer the money faster than the proceedings would require, and the suspension obligation would require. So in practice, Canon found an interim buyer, and there was a transfer of 95% of the shares of the business acquired for the amount of 800 euros. And then separately, the 5 remaining percent were transferred to Canon, together with an option over those first 95% for a price of 5.28 billion. So you can see here that obviously the Commission may have had questions about, the incentives of the parties. So in that case, I think it will be very interesting, because it's the first case where the Commission will pronounce itself on warehousing structures since the Lagardère case. The Commission hasn't really taken any position on this kind of structures so far, although I think the case law tells us that this is something normally that should be allowed. And in that case, I'm just wondering whether this is not because this is so extreme, maybe, that it looks a little bit like maybe it was a sham, and that there was de facto a transfer of the economic value together with this 5.28 billion euros. So this is to be watched out. There was, just for information, a supplementary statement of objection in November 2018, so I think this one will have to wait for a little longer before we get the solution. Last but not least is a very recent investigation by the European Commission, which is on a roll on these procedural breaches. So now it's looking into a bit of a different case. This is a merger between Telefonica Deutschland and, if I'm not mistaken, E+. And in that case, the merger was approved with a number of remedies, including some behavioral one. And that remedy was actually the fact that Telefonica Deutschland would offer wholesale agreements to interested parties at the same condition, under some kind of best prices condition, so at the same condition as the average of its other wholesale contracts. So it was some kind of benchmarking if you wanted to have this wholesale contract against all the other contracts of Telefonica. And the Commission found out that actually in this benchmarking exercise, a number of those wholesale contracts were not included, which would otherwise have given a better price or better conditions to those people wanting to get those contracts. So that's ongoing. Obviously, I think that maybe a small comment, this is an extra case where, that may give ammunition to the European Commission to try to avoid behavioral remedies. Michele has mentioned before, the number of cases where you have structural versus behavioral remedies. Obviously, these are much more difficult for the European Commission to monitor. And I think this is a good example here. Maybe as a small point, the parties here are subject to a potential 10% fine, which is the same range as for gun jumping. The other procedural infringements, which are misleading or incorrect information, are subject to a 1% fine, which can still be a lot of money, because 110 million for Facebook and 52 million for Canon are obviously not insignificant. I'm very cautious about the time, but I'll still say maybe, can I have 2 minutes on the guidelines? 1 minute, okay. So just so that you are aware, the Commission is, at the moment, as far as we know, looking into draft guidelines on document productions. So as I said, as an introduction, in more and more cases, or I should say in the complex cases, the Commission is using more and more extensive document requests, which is a way for them to verify actually what the story of the parties are saying. So they want to check internal documents, emails, things like this that can go back up to 3 years, if not 5 years in some cases. These document requests, from experience, are extremely extensive. They can delay a bit the review process. So the Commission thought, and obviously, practitioners can only encourage that publishing guidelines would be useful. And they've been using some internal guidelines. So the idea was to engage with stakeholders and then to issue public guidelines on those document requests. So that has been put on hold, and personally, I don't really know why, but we're still hoping to get more clearance, being a bit provocative here for Michele. But very, very quickly, these would concern only complex, so document requests would concern only complex cases, but that can also include some phase 1 cases, maybe worth noting. The search terms are usually quite broad, also from experience, although there is some margin of discussion with the case team to get to something which is quite acceptable and reasonable. There has been some issues with documents involving custodians from the legal departments of the parties. So obviously that raises issues of, how likely there would be some privileged documents in this correspondence typically. And then the last point very quickly is indeed access to documents subject to legal privilege, because the Commission in these guidelines, but also traditionally in engaging with the parties, is basically saying that, that only documents covered by the legal privilege as defined by the European courts can be excluded from the documents you submit to the Commission. And that raises a number of questions about this definition. The first one being the fact that this case law has been based on antitrust cases and non-merger cases. And the second one is that if you have a transnational transaction, in particular involving the US, everything which is privileged under US law wouldn't be covered by the legal privilege. So, yeah, I think that's it for my presentation. Maybe just one last point, because it's important, is the fact that you have to sign a declaration that everything you submit is correct. And then, that circles back to this risk of providing incorrect or misleading information. And it's a very heavy exercise, which is done in a very short time frame, and that puts a lot of pressure on the parties, especially if they have to sign and are liable of a potential 1% fine for this. Thank you.